So Trevor Summer decided, I'm going to do this by myself. I am going to represent myself at trial. And we've watched him over the last few days cross-examine his ex-wife, bring on his ex-wife during his case. Even brought on his mother during his case. But this morning, now we are going to watch the culmination of the trial, because when you defend yourself, you also have to deliver the closing argument to the jury. And that's where we're going to begin today. Here is Trevor Summers trying to get the jury to spare him.
I'd like to just be able to share with you a re-representation of what we've heard over the last week. And I'd like to start with just helping you understand from the details that were given and consider that the condition of both myself and Mrs. Mathewson were not adequate enough to truly paint a picture that you could understand. If you recall, we spent a lot of time that weekend just talking, just trying to figure things out, wrestling around, fighting about a variety of issues. Some of them you heard about, some of them you haven't. But you do remember that we didn't sleep very much. Our emotions were all over the place. Our stress was high. You've heard these things through her testimony and through statements of others in this case. And so I ask you to please keep that in mind as you look through, as I walk you through the facts that were presented. I first ask you to pay attention to the photographs. As you walk through the photographs, I ask you to please look through them and notice things in the residence of Mrs. Mathewson. That there were no signs of a struggle, that there was not broken glass or dents in walls, there's not scratches on countertops or blood splatter. This was not a scene that depicted some kind of crime or some kind of anything more than what she described as wrestling around. And I also ask you to look and see that the things aren't thrown about as she described. Things are where they're supposed to be. You can see that we packed, we left, and we had a plan to go to my house. Her accusation is that she was tied to go to my house. But I ask you, does it make sense to go meet children with a woman tied up? I also ask you to look at the items that were disturbed by law enforcement during their 3 times investigating that home. There are a number of things, statements that were made, including a variety of articles within the home that weren't brought in front of you, so that you can't make conclusions, so that you can't corroborate the stories or the statements that were made here. I ask you to look through the pictures of the vehicle. I ask you to consider that they don't line up with her stories either. Little things like the pancake platter sitting in the 2nd row and not the 3rd. Little things like a purse being full of all kinds of contents that were helpful to her, useful to her, that she didn't really need if the whole intent to take her somewhere and kidnap her or steal her car. Why would she need her purse? Why would she need her phone? Why would she need her charger? It doesn't make any sense. And I also ask you to look at the car handle. The car handle's far up in the front of the door. And her statement is her hands are tied behind her back. I think most of us understand that if you lean your back against the car door and you pull the handle, you're going to fall out, you're going to tumble on your head. But she didn't say that happened. I also ask you to look at the pictures of Mrs. Mathewson. You'll see the full pictures when she was evaluated and examined after these events. You'll see that the bruises line up with wrestling around. You'll also see marks, bruises on her arms where she said, I lifted her up through a ravine. And you'll see exactly that's true. We pulled her up through a ravine. You'll see that there are blisters on her heels. Again, I mentioned to you guys, or I questioned her about why she didn't put flip-flops on, or why she would put shoes back on if she already had marks on her heels. And her answer is non-responsive. And so...
Objection, Judge. Inappropriate misstatement of the facts.
Hold on.
Well, I'll instruct the jury at this time that what Mr. Summers says during closing and the attorneys during their closing is not evidence in the case. I will instruct you to rely on your own recollection of what the testimony and evidence was.
Just remind you that they showed the time on the receipt of the McDonald's slip, and that it was a Monday, and it was just before 7 a.m. Also, then ask you to consider the testimonies of the people given. The first is Randall Cosby. Again, he does not recall where I came from. He does not recall what clothes I was wearing, what clothes she was wearing. His statement is pretty inaccurate. He doesn't recall what vehicle it was that was 15 feet from him, even though the name and the insignia is right on the back of it. Only he was focused on was getting that license plate. He was paying attention to that, not what was happening with us. I don't understand how he could be able to look at the vehicle and get the license plate at the same time pay attention to what we're doing. He was also on the opposite side of the vehicle in orientation. He's standing by a red box machine. As you look through the videos, as you look at the overall of that store, you'll see that his position was not a very good view of our position, of Mrs. Mathewson running away, of my position coming out after her. He did not chase us. He did not follow us. He was also the only person standing outside at that time. You'll see a few other people walk into the store a little bit later. All of these people were also available to Ms. Mathewson to go and talk to. If I'm in the store, she could have went and talked to him or tried to seek help from him. He also, in his 911 call, you can listen to that, it says that he didn't even know the street location of where he was working. He didn't know that the place of his employment in his testimony, or what time he started the shift, what time he ended. He was also not close enough to hear the things that were being yelled at each other. Mrs. Mathewson said that she yelled. We were screaming at each other as we were going back to the car. But he couldn't hear that. I then point to you to Kimberly Shea, who gave you a very accurate evaluation of what she saw. Her statement was true. She was pulled in directly across from the passenger side of that vehicle. She saw the emotion on Mrs. Mathewson's face. She saw that we were in some kind of an argument, some kind of a torment. And she also saw Mrs. Mathewson's hand. She saw her hand leaning on the door sill and leaning up against her face. That wouldn't indicate that her hands were tied at all. I also point you to Ms. Shea's knowledge of the exact type of vehicle it was from the moment that she saw it, color, the position, how far she was exactly from the vehicle, and that we left.
All right, the defendant, how's he doing so far? Delivering his own clothes. We want to know what you think about this trial. Join the conversation on Twitter. You can tweet us the questions and comments that you have at Court TV. Coming up, the defendant argues in his close that investigators didn't test several pieces of evidence to corroborate the victim's story. That part is next. Trevor Summers charged with kidnapping his estranged wife.
Please come home.
A 3-day hostage situation. He's not a lawyer, but Summers is representing himself at trial.
This situation is dangerous.
He's going to have to cross-examine the victim, his own ex-wife.
This jury is in for a trial unlike any other.
The estranged husband kidnapping trial, Florida versus Trevor Summers, today on Court TV.
For free at thezebra.com now.
Welcome back. This morning, we're watching the defense closing argument delivered by the defendant himself in the estranged husband kidnapping trial in Florida. Trevor Summers representing himself at trial and facing a jury. This happened last week. The charges: attempted kidnapping and attempted murder. Kidnapping and attempted murder. The victim, his wife, Elisa. She was the state's star witness. He cross-examined her. Now it's time for his closing argument. We're going to pick it up right where we left off.
Then we go to David Chesla, Dr. Chesla. Dr. Chesla did not operate on me as he stated. He also doesn't remember even seeing me. He could not tell exactly what time and what type of medications were given to me. She's only assuming from some records that he may or may not have been involved with. He doesn't know what the volume of the doses were or what types of medications could have had. He didn't testify to what kind of impact those combinations of medicines could have had. He did not speak with law enforcement, and his responses were quite vague. Then to the other medical professionals that testified. Teresa Wagner, Rita Hall, and Francesca O'Neill. They were all involved in some kind of DNA analysis or some kind of evaluation of Mrs. Mathewson's injuries and the sexual battery kit. And again, that sexual battery kit, the test came back, no evidence of rape pointing to me, no DNA match to me. And this happened immediately after the alleged sexual encounters. This didn't happen after Miss Mathewson showered. Her allegation is that this happened on Sunday, and this test happened, and the rape test was given to her on Monday. They also tested the clothing from Mrs. Mathewson, and none of that tested positive for myself being in contact sexually with Miss Mathewson. The sheet from the bed tested positive for my DNA, which the analyst said could have been there that day or sometime prior to that. As you do know from Mrs. Mathewson's testimony, we were in contact prior to the 11th of March. I also ask you to consider the testimonies given by law enforcement. They were not a witness to anything prior to a simple, peaceful arrest. I did not resist. I did not have any testimony of me causing any problems or acting in any kind of irrational way with them when I was arrested. They did not attempt to investigate, despite all of this available DNA, fingerprint analysis, things that could have corroborated the story, maybe made it a lot more sense for you. But they did not attempt to test the pillows to say, yes, this is evidence of her accusation. They did not attempt to test the Christmas lights to see if there's any trace, as the fingerprint expert testified to see if there's anything on the glass bulbs or any kind of skin, any kind of anything with these Christmas lights. They did not attempt to test all of those items in the vehicle. I asked Mr. Becker, could this have been tested? Could this have been tested? And it was their position that, yes, it could have been tested. And if you think about it, think about all the things. When you look through those pictures, look at all the things that were in those vehicles and line them up with Mrs. Mathewson's testimony and see, would those things have some value? I believe you would find that to be true. I also believe that the contents in the trash can, the rope, they collected it, but it was not tested to see if there were any kind of skin or DNA evidence on that rope. That probably would have been a good thing to do. They did not check the NyQuil bottle, the other bottles, the broken wine glass. Look at all these things. They did not check to see if any of those produced any kind of evidence that would corroborate the allegations against me. So you have to ask yourself, is that reasonable? Is that fair? They also did not check anything about this statement that they collected from me in a hospital that was taken after, again, you know that high dosage of medication was given to me. They did not check to see if there were boat charters on any kind of schedule or any kind of thing that could have even corroborated my story there. They did not check to see if I had offshore accounts. They did not check to see if any of these directions that I'm giving. If you listen to that interview, I'm talking about this road and that road. I don't know. Maybe you guys are familiar with the area. Maybe you know.
Objection, Judge.
I will instruct Mr. Trevor not to place the jury in your shoes or the shoes of any party. Don't make arguments like that where you to the jury.
Okay.
You can argue the facts, but avoid what you just did.
Gentlemen, I would just assert that the law enforcement did not check to see if these directions even fit to a map. And they also didn't seem to think that the statement about immigrants was a little bit out of whack. I encourage you to listen to that video or that audio of this interview and see if someone really does sound like they make sense, or if they sound like something different, in fear, in panic, concerned. Look at the condition that I'm in, look at the medication given, and please draw a conclusion from that. I also submit to you that law enforcement failed to recognize any red flags or false statements regarding if I owned a house and if I was able to just sign it over to somebody. If I owned a car and just able to sign it over to somebody. Or even if the passwords to the bank accounts were valid or not. These all would have been important for you to make a decision about whether or not I was giving correct information. The police also purposely did not interview me when I was awake, sober, clear-headed, or recovered. They only interviewed me one time at a hospital where I was vulnerable. That's it. There's no other time. They didn't come and ask me later if I could please explain things better to them. They didn't come with a written statement and ask me to sign it. They didn't try to attempt to get any other information from me. They thought, case closed, he said what he said, and that's it. I also submit to you that law enforcement made no attempt to follow up on the marks on either side of Mrs. Matthewson's neck. Again, they took some basic statements and said, oh, you know, it's been a long weekend, we're just going to conclude here. Law enforcement also could have taken more items into evidence to fill the holes in the story and to corroborate this story. And I believe that would have been much more helpful for you to make a decision in this matter.
Trevor Summers talking to the jury. It's an all-male jury of 6, and trying to convince them that the investigation was flawed and that things weren't done properly. Themes that we do see in other cases, just being presented a little differently because, of course, he's not a lawyer, and it shows. Joining us now, trial attorney and former prosecutor Imran Ansari. He's in New York, and trial attorney C.K. Hoffler in Atlanta. Good Friday morning to both of you. Imran, your thoughts on this train wreck?
Yeah, listen, Ted, it's a gutsy move for a defendant to go pro se, represent themselves at trial. We know Trevor Summers went through a number of attorneys when he finally decided again that he's going to be representing himself. And I think we see it here in this closing statement, in this argument summation by Trevor Summers, why you may not want to do that. Now, it's not a train wreck as we've seen in other trials where we've seen summations by pro se defendants. There's been some of them which have been really bombastic, really out of the out of this world. This one at least is a little more tempered than some of the other pro se defendants we've seen sum up in their cases. He's hitting points which he, I think, believes he wants to hit, but I don't think the evidence elicited during this trial really backs up his arguments. And of course, we know Trevor Summers, he had the outcome from his own summation at the end of this trial. But I think you see the cautionary tale here. It's not good necessarily to represent yourself. Of course, it's your right to do so, but it's often better to go through this process with an attorney.
Yeah, probably not a train wreck, CK. More is that the train doesn't seem to be working. Your thoughts?
Well, I do think it is a train wreck. For this reason. My goodness. He's making distinctions, and first of all, I will say this. His temperament is very good. His temperament was good when he was doing the examinations before, and that is a good thing. But in a case like this, you simply cannot represent yourself, and this is Exhibit A of why you should not represent yourself when you're facing multiple counts for criminal activity where you could end up in jail. And what I think he's completely missing in this picture is his confessions. He's drawing distinctions with the evidence without recognizing that the jury has heard confessions, that his testimony coincides with his wife's testimony. And he's not denying, he's trying to, show distinctions in what law enforcement did and maybe this evidence did, but he can't deny the fact that he actually did this. And that is why he must be represented by counsel, because there is no reasonable doubt as to his criminal activity. And that's why this is a train wreck, a big train wreck, a colossal train wreck, in my impression, Ted, not because of his demeanor in the courtroom, but because of the case, the evidence, and what the jury has already heard. He should be poking holes in that, but what he's doing is affirming it. And so that makes it a disaster.
Yeah, it is fascinating to watch, though. Somebody in this situation. We'll take a break. Coming up.
Then we turn to the children. They only said a few things. I didn't ask them much. I didn't believe they even said too much of value, but the little bit that they did said, it contradicted their mother being dragged down a hall in the house.
Trevor Summers attempts to use the testimony of his children as a way to discredit his wife. We'll have more of this closing argument straight ahead.
Ready?
Then we turn to the children. They only said a few things. I didn't ask them much. I didn't believe they even said too much of value, but the little bit that they did said, it contradicted their mother being dragged down a hall in the house. It contradicted what their mother said about being restrained in the corner of the living room. It also shows that mother had no interest in speaking to them when the oldest, Arden, came into the home, while the youngest two were into there. There was no information given to them. There was no concern to them about while Mrs. Matthews and I are arguing and fighting in the home. And then we turn to the statements of Mrs. Matthewson. These statements were outrageous. The statements were exaggerated. The statements were, most of them, impossible. The responses to simple questions were abrupt and over the top. The calm answers, if you recall, they revealed some truths, such as wrestling in the living room. That's a true statement. Such as sleeping in the car. That's true. Such as not caring about sex. That's true too. Such as just calling it sex. That's true. About being woken up by water droplets rather than some other crazy way. If you guys remember the timeline that was presented, they say that I came to her house at 12:30 in the morning, and she finally woke up around 3. Text message showed between me and my children, and I'm trying to wake her up. Showed that I tried to turn on the television loud, I tried to put lights on and off, tried to slam some doors. I think you guys can understand that. I also ask you to pay attention to the statements that Ms. Mathewson made. She drove to my neighborhood after these prior allegations. She said nothing to our children to help her in this alleged situation. She was already in the bedroom, and she made no statement of being drugged back into there. She claims an entire bundle of rope fit in my jeans pocket. That rope, again, was not tested to see if used in any allegations here. She claims that there was a sock in her mouth, but does not recall those details. And as you go through the evidence, you'll see that no sock was recovered. You'll see that no sock was tested to corroborate this claim. She claims that duct tape was on the mouth, but again, nothing corroborates this. You have a picture of duct tape. You have a very simple thing that law enforcement could have tested and said, yeah, what she said is true. That's not here. You also have a statement about predominantly calling it sex, and then has a cigarette after each time. She offers no details like in the other accusations. We just had sex. and we move on. She also says that she was screaming when she came back to the vehicle at Walgreens. And again, no witness made this kind of observation. She says that she opened her car door with her back to it and did not tumble out on the ground. She says that she refuses to recall the majority of the time we were together over the weekend. If you recall, we were together roughly 30 hours parked in the country, in the woods. But she can't remember most of the conversations that we had. She also says that we were driving around on Monday morning between the hours of 6 a.m. and 10 a.m. on some very busy roads. But she made no effort to signal another car or really elaborate on any of that time for you. She also states that we argued throughout the weekend. And that should truly help you understanding the range of emotions that were happening, the things that were happening in a divorce situation.
Objection, Judge. Facts not in evidence.
Again, I'll instruct the jury to rely on their own recollection of the facts were. I'll caution Mr. Summers to please avoid arguing or referring to any facts that were not testified to in this case.
Trevor Summers charged with kidnapping his estranged wife, representing himself in court.
This jury is in for a trial unlike any other.
The Estranged Husband Kidnapping Trial, today on Court TV.
Today. Welcome back. We are watching closing arguments in Florida versus Trevor Summers. Summers faced multiple charges, including kidnapping, sexual battery, and attempted murder against his now ex-wife. Summers fired his public defender, early in the trial. He was able to cross-examine his ex-wife. He brought on his mother in his case in chief, and now he is delivering his closing argument to the jury. Let's get back into court as he wraps it up.
And then we'll go to my interview. If you evaluate me on this statement made in the hospital, I hope you find that it doesn't make much sense. I hope you find that there are a glaring number of issues, sometimes in, sometimes out. Things about, again, bolts and incongruent driving directions, about immigrants, about a variety of things that really show a concern for the situation I'm in. So please evaluate that based on the conditions that you know surround that interview. Aside from this, gentlemen, I just remind you that from the beginning, I've assumed my presumption of innocence, and I maintain this until now. I assert that the state has not proven what was in my heart, especially regarding 2 counts of
Objection, Judge. Inappropriate requirement of the state to prove what's in his heart.
I'll instruct the jury that what Mr. Summers say is certainly not the law. In this case, the law will come from me, and the elements of the crimes will be contained in that law. Mr. Summers, restrict your argument to the law and the evidence in this case, please.
Yes, sir. I'll rephrase that, gentlemen. The state has not proved my intentions. They have not proved that I intended in counts 1 and 2 to kill Mrs. Matheson. In my statement in the hospital interview, I clearly never said I intended to hurt her. If you're relying on that, fine. I never said I intended to kill her with a pillow, and I never said anything about the rope. Never mentioned the incident one bit. I'm also going to assert that they did not show any intent to steal a car. They did not show that that was the underlying reason that Mrs. Matheson went with me. They did not show that I intended to kidnap her. There's a lot of holes in their story, and I ask you to please consider that when evaluating whether or not you find the facts true. They also did not show my intent to take advantage of Ms. Mathewson in any sexual way. You've heard the way I've described it in my interview. You've heard the way she's described it, and I hope you can appreciate that. I also believe that you would find that they did not prove that I intended to steal a car, which is one of the later charges on this long list that they've put together. I believe you would find that it is a civil matter, and that when two people are married, they commonly use each other's vehicles, even if they are separate.
Objection, Judge. Improper argument.
Again, I'll instruct Mr. Summers to limit your argument to the facts and the law that are applicable to this case.
Gentlemen, I assert that utilizing cars while married is a civil matter. I also don't argue other issues. I ask you to just be favorable in understanding my position here. I ask you to please be cautious in understanding what burden of proof the state has to provide and how high that threshold is, that you cannot have doubts about these allegations. They are very serious.
Objection, Judge. Misstatement of the law.
I will instruct the jury that, again, what Mr. Summers says is not the law. You will hear the definition of reasonable doubt when I instruct you on that law.
And so, gentlemen, reasonable doubt, I believe, is everywhere. And I ask you to please remember that and to please focus on that. That element that has to be proven by the time that you make these decisions about my life, about the situation that you've been presented, about deciding whether or not to find me innocent or guilty. I ask you to please consider all of these factors and see that what I am trying to show you is that this was a very abnormal series of events, and it requires a lot more information for you to draw a conclusion that would say that I absolutely am guilty of these crimes. And so for all of these reasons, gentlemen, I thank you for your time. I thank you for giving me the opportunity to explain this to you and to share with you a better understanding of putting it together. I thank you for allowing me to paint a little bit better of a picture, and I do appreciate your time, and I value your opinion on this. And I do ask you to please find me innocent of the charges against me, and to consider what else may be available to you as you are instructed by the judge. Thank you. Thank you, gentlemen.